Okay, so good morning, good afternoon, good evening, everyone. Welcome to our webinar on key issues for developing countries in the tax challenges of the digital economy, the discussion which is going on in the OECD's inclusive framework, which we have co-organized with the Global Alliance for Tax Justice. Thank you very much for your interest. This webinar is a forum or a platform by the South Center for providing a space where developing countries can put forward their views, their concerns on this genuinely historic negotiation. After more than a century, the fundamental aspects of international taxation have been put into question on how nexus is determined, on how profit is reallocated to account for the digitalized aged, the new sort of digital business models which are proliferating and which have created serious tax challenges for administrations around the world. And this has become especially important in the post-COVID era when countries are more stressed for raising revenue. So it's all the more important that some sort of a solution is found which is in the interest of developing countries. So with that objective in mind, we are really privileged to put together a panel of some of the most prominent, influential, and committed voices of and from the Global South. And with that, without further ado, I would like to invite the Executive Director of the South Center to give the opening remarks. Dr. Carlos Correa is a world famous authority in intellectual property. He has been the Executive Director of the South Center in 2018. Previously, he was the director of the Center for Interdisciplinary Studies on Industrial Property and Economics at the University of Buenos Aires. He was also a member of the UK Commission on Intellectual Property Rights and the FAO's panel of eminent experts on ethics in food and agriculture. So without further ado, I invite our ED, Dr. Correa. The floor is yours.
Thank you very much, Abdul. On behalf of the South Center, let me welcome very warmly all participants and the speakers for this important webinar. Let me also express our satisfaction for organizing this event with the Global Alliance for Tax Justice, an organization which is very well known for its competence and skills in this very complex area of taxation, and also because of its impressive record in fighting against inequality in taxation. So we are very happy actually in organizing this meeting together. This meeting is particularly timely for two main reasons. On the one hand, as you know, a few days ago, the G7 Ministers of Finance announced an agreement to set a global minimum tax of 15%, which is lower than the original proposal by the Biden administration. But interestingly, again, this decision was taken without the participation of the South, of developing countries, outside the United Nations. I've taken note in particular of the frustration expressed by the Secretariat of the Global Alliance. The Secretary Coordinator indicated that this is déjà vu. This is again a deal among themselves without taking into account fully the interests of the Global South. On the other hand, this event is timely because the OECD inclusive framework aims to come to a solution to taxation of digital economy by July, not later than October this year. And therefore, there is a critical need for developing countries to organize themselves in order to ensure that taxing rights in the context of digital economy are recognized. Their taxing rights are fully recognized. And this, in this sense, is essential to mobilize the administrations in developing countries to strengthen the capacity to influence the outcomes of this so-called solution. And of course, getting the right taxation is crucial for developing countries to face the current devastating situation that's been created by COVID-19, and beyond that, certainly in order to achieve the SDGs. So we are very happy that we have been able to organize this meeting. As you know, the South Center Tax Initiative has as a major role this objective of trying to bring together developing countries in order to strengthen their capacity to influence these outcomes, in addition to providing the technical assistance, advice, and information in this area. So let me just thank again our distinguished speakers. So it's a real privilege for the South Center to have you on this panel. Let me thank the participants for joining us. There are 6 key issues that have been put forward for discussion on this meeting, which are presented in the concept note. I'm sure this will lead to a very fruitful discussion and will enhance the capacity of our countries to ensure that the solution which is found actually reflects the interests of the Global South. So thank you very much again, and I wish you a very positive and fruitful discussion.
Thank you very much, Dr. Correa, for those illuminating inaugural remarks. And I would now pass the floor to our co-organizer, Dr. Derege Alimeyehu, who is the Executive Coordinator of the Global Alliance for Tax Justice. Dr. Alimeyehu has a very distinguished record of serving the Global South. He was the founding chair of Tax Justice Network Africa. He has been a senior advisor to Christian Aid. He is also a senior advisor to the global the Tax Justice Network Africa, and the Global Alliance for Tax Justice under his leadership has in fact been nominated for the Nobel Peace Prize, which speaks for itself in terms of the impact his work has had. The Publish What You Pay initiative, which has provided transparency in the extractives industry. So Dr. Alimeyehu, we are very privileged to co-organize this event with you, and I will invite you to deliver your opening remarks.
Thank you, thank you, Abdul, for the kind words, and thank you, our eminent speakers and all of you who have joined here. The Global Alliance for Tax Justice is a coalition of continental-level tax justice networks in Africa, Asia, Latin America, Europe, and the North America. And as you see, it is structurally a southern-led alliance. So that is why the weight of our work is to promote the interest of developing countries in the tax arena. Let me start by making some critical remarks about the inclusive framework itself. We have been, as Global Alliance, critical of the inclusive framework from the very beginning, because we were worried that a global issue of huge importance is being negotiated and decided behind closed doors in an informal institutional setup created and led by the Club of the Rich. We believed it is yet another attempt by the Club of the Rich to sideline the United Nations as the only legitimate institution with universal membership mandated to rulemaking and standard setting on global issues. Has this not been the case, the OECD could have put its unquestioned technical expertise on tax issues in the service of the United Nations, on the basis of which the UN could have facilitated an intergovernmental process for a political agreement. For example, the OECD Task Force on Climate Change is not tasked with facilitating rules and regulations on climate outside the UN. The findings of its experts flow into the universal negotiation process under the auspices of the UN. In addition to being worried about its legitimacy, we are now increasingly worried that the inclusive framework has become Bermuda Triangle, in which issues, concerns, and proposals put forward by developing countries disappear. Where did the G24 proposals and the ATAF reservations go when the OECD Secretariat developed its blueprint? What will be the fate of the recent G24 submission and the ATAF counter proposal in the final round? I wish I did not know the answer. Furthermore, we are worried about the fine print in the package the powerful OECD Secretariat will try to sell as a consensual agreement of 140 jurisdictions. We are worried that mandatory and non-optional dispute resolution arrangement and retaliatory measures to make unilateral actions impossible would be part of such a fine print. We are worried that the machinations and manipulations in this non-transparent process are veiled in Orwellian language for propaganda purposes to make them appear that solutions are being sought and found. How many would understand that what is on offer in Pillar 1 is allocation of a derisory percentage of global multinational profits? Who would understand that the historic agreement on establishing 15% minimum tax cements the usurpation of taxing rights by rich headquarter countries? We are worried that there is a concerted effort on the part of rich countries to lock developing countries into an agreement which will bring insignificant benefits today, but will continue to deprive them of taxing rights on part of global profit generated in their economies for many decades to come. In sum, we are worried such a process dominated and manipulated by the rich will not curb tax evasion and avoidance and other forms of illicit financial flows from developing countries. That is why we are calling developing countries to dare to say no to deals which will bring at best tiny benefits today, but would perpetuate the status quo in the long run. Let's build our houses on our own pillars. Thank you very much.
Thank you very much, Derege, for those remarks. And before we begin with the panel, I just want to make a few housekeeping announcements. Please keep your mics off. But we encourage you to keep your cameras on, especially during the question and answer session. And if you would like to have any questions or comments, both are welcome. The raise hand button is under the reactions tab. Alternatively, you could also type them out into the chat. The webinar will be recorded and it will be shared with everybody who has registered. So it will be available for your reference later on. So with this, it is now my great honor to begin the introduction of the panel. The first speaker would be Mr. Carlos Proto. Mr. Proto has been, well, he represents Argentina in the inclusive framework and has been doing so since 2009. And he, at the same time, is also a member of the UN Tax Committee, officially known as the UN Committee of Experts on International Cooperation in Tax Matters. In both forums, he has been extremely active, championing the issues of developing countries, the interests of developing countries. He is also active in many capacity building programs. He is on the group of experts on taxation of Mercosur. And we are privileged to have him as a speaker, and he will be speaking, in fact, on what is arguably one of the most important questions, which is the question of allocation. Who actually gets the redistributed funding? So without further ado, Mr. Proto, I invite you to make your presentation. The floor is yours.
Thank you, Abdul. Thank you, South Center and the Global Alliance for Tax Justice Network for inviting me to present this important and relevant and, as Mr. Correa said, opportune issue. So, as he has mentioned, in 2 weeks' time, the inclusive framework will be taking a decision on whether to agree or not to agree on what has been described a new tax system, a new reallocation of profits among jurisdictions to address the tax challenges of the digitalization, but not only that, also to address the tax challenges of globalization. So if you allow me to share my screen, I will go through the slides I have prepared for this opportunity. So we can start discussing what is the new approach under Pillar 1 of the expected global solution to address the tax challenges of the digitalization and now globalization as well. So I hope you can see my screen. What is all of this about? So as you may know, current international standards are not efficient enough in order to address what has been considered the problem posed by the digitalized economy. So jurisdictions are now allocated with taxing rights on profits generated by business activities, depending on the existence of a permanent establishment through which the multinational enterprise derive the income. So in the absence of a permanent establishment, jurisdictions where activities are performed or income is paid out of is not in a situation where a taxing right can be exercised because of the tax treaty network that that jurisdiction may have enforced and prevent that jurisdiction from taxing business profits in the absence of a permanent establishment. That's the standard, which is in Article 7 of both the UN and OECD model. So in the absence of physical presence, no taxation at source. So the problem is multinationals are now able to access markets, remote markets, without needing any foot on the ground. So business activities are taking place in a digital way without creating or without trespassing the threshold for taxation being granted to market jurisdiction. Pillar 1 is now trying to address this, trying to reallocate taxing rights to market jurisdictions where profits are generated in the absence of fiscal presence. How is it expected to be undertaken? That's something that has been discussed under Pillar 1 of the global solution proposed 2 years ago by the OECD Secretariat and explored by 139 jurisdictions expected to work in an equal footing. So under Pillar 1, there is an amount A, which is designed to allocate taxing rights to market jurisdictions with regard specific multinationals that will be subject to that taxation in the market jurisdiction, but not on the entire profitability, just on what is called non-routine profits. So now, if we stand on the current standard, there is taxation on zero profits. According to amount A, it is expected to be taxation just on non-routine profits. Non-routine profits are considered to be those that are derived in excess to what is considered to be routine profits, which are those that, according to current standards, are remunerating different elements in align with the arm's length principle. Those elements are functions performed, assets involved, and risk assumed in the business activities. So if there is profits, or if there are profits that does not remunerate any of those elements according to the transfer pricing analysis, those are the extraordinary profits, the non-routine profits that are targeted by amount A. In order to avoid complex analysis on what are the non-routine profits for a specific business activity, amount A introduces a simplification saying that for sakes of simplicity, administrability, and to reduce excessive burden on taxpayer to determine the tax base, there is a kind of convention saying that routine profits will be deemed to be a specific portion of the total profits. So such portion has not been decided yet. We have heard 10 days ago that G7 suggested that the profitability margin out of which Pillar 1 will provide a taxing right for market jurisdiction will be 10%. But that has not been decided yet. Hopefully, a decision is taken in 2 weeks' time. favorable or against that, but a decision is expected to be taken. So let's assume by now that 10% will be the margin out of which any payment or any profit in excess of that will be considered to be non-routine profits and subject to the new allocation of taxing rights. So now, what is the portion of the non-routine profits that will be subject to tax in market jurisdiction? That's the reallocation percentage. We have also heard from G7 that they favor at least 20% of the non-routine profits to be taxed in market jurisdictions, while, however, most developing countries have favored a higher percentage, at least 30%, and why not 50% of the non-routine profits. So this is another issue for a solution. Let's hope that the inclusive framework is able to decide on this as well, taking into account that the higher the portion of the pie is shared among jurisdictions, higher collection will be, and more activities could be supported by that, helping and contributing to resource mobilization. So that's something to take into account for developing countries where resource mobilization is an important issue. And the 2030 agenda is claiming for. So now, after that tax-based determination, it is useful to say that single jurisdiction will be allowed to tax that portion of the pie if it meets the nexus requirement. It has not been decided yet, but it is expected that the revenues derived by the MNE from that jurisdiction has to be at least 1 million to be decided, but it's more or less the common idea, while allowing the least developed jurisdictions to apply a lower threshold around 250 euro per year. But that's something to be explored. It will depend on the GDP of that jurisdiction in order to see whether the 250,000 euros could be applied, or it has to apply the general nexus threshold of 1 million euros every year. So if it meets the requirement, then it can tax a portion of the non-routine profits, depending on the proportion of the sales of that particular MNE in that particular jurisdiction in comparison with the entire sales around the globe. So it's a kind of formulary apportionment that is expected to apply here. Now, to make it clear what we are talking about, we see here a green bar. That's the entire profitability of a particular MNE. From that, we can take that only a portion of this will be considered to be routine. So the yellow part is the non-routine and the one subject to taxation in market jurisdiction, but not all the yellow portion of the profits, but just a portion of that. That's the reallocable portion, the 20, 30, 50, whatever is agreed by the inclusive framework, but only that will be shared with market jurisdictions in order to exercise any tax on that. So I hope it's been clear enough on what is the profit allocation that is expected through Amount A and Pillar 1 in order to reestablish the international tax system in order to address the tax challenges of the digitalized economy. Just to sum up, I would like to share with you some views expressed by some developing countries among the inclusive framework members. If Amount A is expected to increase the tax base and to provide an equitable tax treatment, so developing countries have been interested in order to achieve that, to have a change in the current proposal, or at least to have a consideration that a low threshold of global revenue to determine the M&Es that are in scope will favor that aim. So it's not been decided yet, but the scope is an important issue. It will determine how many M&Es will be subject to amount A. So the tax base is directly linked with that, because the higher the number of M&Es participate in this kind of taxing exercise, so the higher the collection would be, and the more resource mobilization could be also achieved. It's not been decided, but according to a proposal, it is expected to be around 20 billion euros per year, the global revenue, according to which the size of the M&E is decisive in order to see whether or not it will be subject to amount A. Remember that according to the blueprint, which has been published and open for comments by the international community in January, according to that, only the threshold was only 750 million euros per year, so much more lower than what is now on the table. So that's something that developing countries have been claiming for, to have a reduced threshold to determine M&Es that are in scope. Moving to the allocation of taxing rights, the profitability ratio has to be determined, and also developing countries favor a low profitability ratio in order to determine the non-routine profits that will be taxed in the market jurisdictions. Regarding the reallocation percentage, that which is now between 20 and 30, regarding views expressed by members of the inclusive framework, as it has been pointed out, C24 and ATAF have presented a proposal saying that the higher the reallocation percentage would be, the better for the developing countries, since a bigger portion of the pie will be shared among themselves. And finally, the threshold for gross revenues in market jurisdiction to determine the nexus has to be the lower as possible in order to allow every single jurisdiction to have an entitlement to exercise the taxing right. So that's what has been expressed by developing countries at the inclusive framework meetings and any of their sub-organs, in particular the task force on digital economy. So now we need to take into account there is another solution, probably developed further today in this session by another panelist. But the UN proposal has a clear difference here. It does not only allocate a taxing right on the non-routine profits, but on the entire profits. So that's a main difference between these two suggested solutions, and happy to encourage all developing countries to analyze this and to understand what their position could be, how would be the impact for that particular jurisdiction in addressing this proposal and exercising the right it has to take a decision later this month in the inclusive framework, in order to see whether or not a consensus could be provided in order to propose a global solution that would address all the concerns expressed. Thank you so much for your time, and happy to answer any question you may have. Thank you.
Thank you very much, Mr. Prato, for that extremely clear and visually clear as well presentation, which I think very clearly showed how the routine, non-routine, that only a small percentage of non-routine or residual profits would be redistributed. And to summarize in a very clear way, what were some of the principles on which developing countries are basing their demands. we have now covered some aspects of pillar one, but we would now be looking at some aspects of pillar two. And that brings me to speaker number two, who is a legend in many ways in the field of international taxation. All of us have here who have been associated with international taxation at some point or the other have either read his works or know his name for sure. He has been a visionary. He has been advocating formulary apportionment a long time before it have found its way into Amount A. It became a part of international standards. He has played a leading role in creating the BEPS monitoring group, which is a very influential civil society organization which puts forward some perspectives for developing countries in technical negotiations in international taxation. He is an emeritus professor of Lancaster University, a senior fellow at the International Center for Tax and Development. Excellencies, ladies and gentlemen, it is my pleasure to introduce to you Professor Saul Picciotto. Professor, the floor is yours.
Thank you very much, Abdul, for those kind words. I have been working in this area for a very long time, so I think my main advantage is my age, maybe, because these problems have been going on for a very long time. Although I do think that we are at a kind of turning point. I think it's still another step on what, as I say, has been a very long road. As Carlos has pointed out, the issues are not just about digitalization. Digitalization is the latest phase of a process of globalization, which I think in the tax area really started particularly back in the 70s with dematerialization of economic activities, which was already manifested in the shift to the services economy. So what we've seen now is the digitalization of services, but already with the shift to services and internationalization of services, many of these problems were already experienced, and experienced particularly by lower income countries, which have been primarily importers of services. So it is a long-standing problem. And it's only finally now, with this latest phase of digitalization, that many also of the more developed countries are experiencing the same problem. So I think we do need to put it in that broader context. And I think we are finally reaching some kind of a turning point where we do at least have a proposal to consider multinational corporations on the basis that they are single firms. The main, I think, step forward, particularly in Pillar 1, is that it does start from the global profits, and we are finally talking about how to allocate the global profits. But obviously, this is in a rather limited way so far. As Carlos has pointed out, the African group has proposed, I think, a much better and simpler approach, and we have to see what comes of that. So that will be a step forward, I think, in some ways a turning point, but not the end of the road. I'll talk mainly about the second pillar, Pillar 2, because clearly to reform international tax rules is quite a difficult task. Implementation of Pillar 1 is envisaged in the blueprint to require a multilateral tax treaty, which I think will be a very difficult undertaking. But the main way of pushing countries into doing that is to address what Pillar 2 is addressing, the problem of undertaxed profits, and also tax competition, the competition among states to offer tax advantages to companies. Now, this is a beggar thy neighbor approach. In the area of international trade, we talk of beggar thy neighbor in the sense that countries attempted to introduce measures that really hit other countries while not really benefiting themselves very much. And that leads to a race to the bottom. So Pillar 2 aims to address this by trying to have stronger international coordination on the taxation of undertaxed profits. Now, I think the blueprint for Pillar 2 in many respects really was very significant. It discussed and put forward technical proposals on the building blocks. So in many respects, it has put into place the possibilities of a really quite effective approach. But the design in Pillar 2 has some fundamental flaws, which I think have been highlighted by comments, particularly from lower income countries. And I think the reason for that is that it is the lower income countries that are most aware of the problem. And the proposals they've put forward, as the G24 group's proposals point out, are actually in the interest of all countries. The proposal to rebalance the allocation of tax rights in Pillar 2, I think would benefit all countries. The major flaw, I think, in Pillar 2 is the imbalance of taxation rights that it proposes. The central element of Pillar 2 is a so-called globe, which has two elements. It has a right for home countries of multinationals to tax under-taxed profits, and it has a right for source countries, countries where activities take place, to tax under-taxed profits, but it proposes to give priority to the home country. Now that's an extension of rules which already exist in many countries, the so-called rules on controlled foreign corporations. These allow the country of residence of the parent company of a multinational to deem its worldwide profits as attributable to the shareholder, to the parent company, and to apply a tax to those profits. Normally, CFC rules are limited to passive income and to income declared in low tax jurisdictions defined in various ways. But the other important element of CFC rules is that they give a credit to source country taxes. So CFC rules in many ways have the advantage that they do give source countries the primary right. But what's proposed in Pillar 2 at the moment is to require priority for the home country, the so-called income inclusion rule. So that would be, the priority rule would be the jurisdiction of the ultimate parent. If the ultimate parent did not apply tax on under-taxed profits, then an intermediate parent company could do so. And it's only if neither of those jurisdictions applies the so-called income inclusion rule that then a source country could apply what's called the under-taxed payments rule. Now, I think quite rightly, lower income countries, both through the G24 and through the ATAF, have said essentially that this is not acceptable. Now, I think that's understood also because the Pillar 2 blueprint does propose a third rule, the so-called subject to tax rule. But that would require changes to tax treaties. That would apply a fairly familiar mechanism for developing countries, denial of a deduction. But the way that it's been formulated in the blueprint, it could only be introduced with changes to tax treaties. And what now seems to be envisaged is to go ahead quickly with the globe, with its two components, the income inclusion rule and the undertax payment rule, and then maybe introduce the subject to tax rule when tax treaties can be changed. Now, I think rightly, the G24 said this is not acceptable, and source country taxation, maybe through the subject to tax rule, should be an integral part. So I think that's really the key element. There's been a lot of discussion, obviously, about the minimum effective tax rate, and I think it's welcome that this talk of having it as low as 12.5% has gone. Now apparently 15%, but 15%, I think even the G7 has said should be the minimum, and certainly a higher rate should be envisaged. But probably as important, if not more important, is rule order, because the issue is who gets the right to tax these under-taxed profits. Now, a group of us from NGOs have put forward what we call the minimum effective tax rate, the META proposal, which would resolve the problem by remodeling the globe and allocate on a formulaic basis, allocate the right to tax the under-taxed profits. So it would use the same building blocks in the Pillar 2 blueprint for defining the effective tax rate and identifying the under-taxed profits, but instead of a top-up tax, it would allocate the undertaxed profits on a formulaic basis to countries on the basis of where the multinational has real activities. And the formulaic basis, I think, is the one that is familiar both from national tax systems in federal countries like the USA, the so-called three-part formula. It's been proposed also within the EU. So it would be a formulaic or formulary approach to reallocate the right to tax undertax profits according to where each company has sales, assets, and employees. Now that would be a balanced allocation of the taxing right. Now, maybe the inclusive framework won't adopt that proposal as it stands, but in any case, clearly a better solution needs to be found for the priority issue. If not, then I see no reason why countries that are primarily source countries should join in a Pillar 2 proposal. There's no way in which they can be required to give priority to the income inclusion rule, and they should not do so. There are other mechanisms that they could develop, either on a purely unilateral basis, but preferably jointly. They could already build on other measures for defending the source tax base. They could introduce alternative minimum taxes. They could defend the source tax base by applying the principal purpose test to deny deductions for payments that go to conduits located in low tax jurisdictions if the motive is primarily tax avoidance. So there are many ways, I think, in which source countries could protect the source tax base themselves. So unless the proposals that have come from G24 and others for a balanced allocation of taxing rights under Pillar 2 are accepted, then I think there will be no reason to join in a Pillar 2 which gives priority to home country taxation of undertaxed profits, which, as I say, goes beyond existing CFC rules. It could only be enforced on countries if they accepted that restriction, and there's no reason why they should accept that. Thank you very much.
Thank you very much, Professor Picciotto, for your presentation, for clearly highlighting the importance of the rule order, the subject to tax rule, and how the proposals at present are going to give the primacy to home jurisdictions, which are to a large extent developed countries, and for highlighting that developing countries should think seriously whether joining Pillar 2 is worth it or if it is in their interests. And if not, then what are the other alternatives they can use to protect their tax base? The unilateral measures, as has been mentioned. Thank you very much for your comments. We now move to our next speaker, who will speak about dispute resolution under Pillar 1. And Amount A in Pillar 1 envisages that if there's going to be any adjustments which are made, then that would be subject to a dispute resolution process. So it is, ladies and gentlemen, Excellencies, it's my great pleasure to introduce Mr. Matthew Gubanjubola. He is the representative of his country, Nigeria, in the steering group of the Inclusive Framework. He is also the head of the International Tax Department of the FIRS. He was formerly the chair of the African Tax Administration Forum's Cross-Border Taxation Technical Committee, and he was the first person from Africa to co-chair OECD's Working Party 6, which is an influential working party on the taxation of multinationals. So, ladies and gentlemen, it is my pleasure to introduce Mr. Matthew Gubanjubola. Sir, the floor is yours.
Thank you very much, Abdul. Good morning, good afternoon, good evening, colleagues all over the world. I have been asked to speak on the dispute resolution mechanism proposed for the Pillar 1, particularly Amount A. I will seek permission to share my screen. I do hope my screen is visible.
Yes, sir, it's visible.
Looking at tax certainty, we are looking at creating and maintaining a very stable policy, legislative and regulatory framework in tax administration, and with the objective of ensuring clarity of tax rules and also ensuring that taxpayers have unhindered access to dispute resolution process. Traditionally, we are used to the dispute prevention mechanism that are available within our different countries, which include bilateral or multilateral EPAs, advanced rulings, safe harbors. We will have benchmark transactions. We will also have joint or simultaneous audits. And for dispute resolution, we will have the MAP under our treaties, and then, of course, we rely on our domestic legislations, wherein we go to our courts and arbitrations tribunals for resolution. What we have under the Pillar 1, particularly the Amount A, is to shift to a multilateral arrangement, particularly that we secure the determination and allocation of Amount A, which is based on a formulary approach, and then to also avoid disputes in the areas relating to marketing, distribution, and all other cases that may be linked with Amount A. Now, the architecture of the proposed tax certainty mechanism or dispute resolution mechanism for Pillar 1 are broken into two. One for Amount A, which will deal with issue of dispute prevention and then dispute resolution. And then for issues beyond Amount A, will dwell mainly on dispute resolution. Now, the question could be, what are the possible disputes that may arise as regards Amount A? There are 5 possible areas of disputes, broadly speaking. One is whether or not an M&A is in scope, and I think the threshold and the profit threshold for M&A being in scope will help to address that, but there are issues around segmentation and all the like that may also come to complicate that. Also, the type of business in scope, and before now, there was the segregation between ADS and consumer-facing business. Of course, the US proposal has sort of matched that together, but there are also issues of carve-outs of extractives, and there are questions as whether agriculture will also come in as an extractive. There are issues of possible financial services. All of this could create disputes. And then the allocation of costs, joint costs, particularly losses to be carried forward. All of this could present a dispute. Existence of tax nexus. Of course, this again is based on the amount of in-country turnover, but then there could be dispute if there are differentiation between the in-country nexus tax turnover for different countries. Then there could be this to also have some measure of dispute, and then finally the issue of relieving or paying entity of Amount A may also present some dispute. Now, for Amount A, the tax certainty is broken largely into two. One is the early certainty process, which is mainly a dispute prevention mechanism, wherein there are panels, review panels, determination panels that are going to be set up under the multilateral agreement. And then the latter part of it is where there are disputes, and this is where the proposal is to have a binding, a mandatory binding mechanism, wherein pronouncement of the arbitration will become binding on the relevant jurisdictions that are part of the inclusive framework. I think for the early certainty process, there are specific issues of scope of that mechanism, which would limit itself to determination of whether or not an MNE group is in scope of amount A, whether the determination of the MNE's group allocation of amount A is agreeable, confirming, paying, and relieving entities. This will be the scope of the early taxing certainty process. And then, of course, the review panel, which are made up of um, members of developed economies and developing economies to review the tax returns of MNAs, and then where there are disputes to submit position paper. And then we have the determination panel, again made up of developed and developing economies, and then they will be determining dispute arising based on position paper provided by the review panel. And of course, the decision of the determination panel will be binding on the jurisdiction if that jurisdiction is an inclusive framework member. Now, with respect to the mandatory binding dispute resolution, it's going to be mandatory for all inclusive framework members, and the outcome is going to be binding on those members. However, the process is not yet not fully defined, not fully agreed, and so the details are still being awaited as to what will constitute this process, this mechanism. But there are mooted suggestions that this will be by way of arbitration. And the scope will be, an objective will be to ensure that transfer pricing adjustment do not create double taxation for MNEs that are in scope of amount A, and two, that transfer pricing and permanent establishment disputes are resolved in a very timely manner. I think these are the major objectives of the mandatory binding dispute resolution mechanism. I think this is where I think the major issue is, and that is, what are the concerns of developing countries? As regards amount A determination and tax certainty, there are concerns that the composition of the various panels are skewed against developing countries. And I think this is a very serious concern for developing countries. Two is the proposal from developing countries, particularly from Africa, via ETAF, wherein suggestion was made to carve out developing economies that have no or very few map cases from this arbitral process. And also there's the challenge for developing countries that the mandatory binding mechanism may not serve the interests of developing countries. And when we look at tax certainty beyond amount A, the concerns are that determination of transfer pricing issues may now be based or be linked to amount A, instead of looking at those issues on the basis of the Hampstead principle, on the basis of the facts and circumstances of each case. Amount A will become a sort of a paintbrush on which determination of TP issues will now be based. There are also the problem that MAP cases will not be allowed to run its course because then you may find that a party may decide to run to arbitration while the process for MAP are still not yet fully exploited. And finally, there is the possible effect of what happens to national tax sovereignty, where internal or domestic transfer pricing cases have to be taken to international arbitration. These are the concerns when we take dispute resolution beyond amount A. And then finally, With respect to the proposed or the mooted mandatory binding dispute resolution mechanism, there are specific concerns in developing countries, and particularly in Africa. There are countries that have constitutional limitations that will not enable them to submit the revenue of their government to arbitration in other lands. And I think this is one issue that had largely been ignored in the current discussions. There's also the concern of the fairness of the system. And I think quite a number of countries have had one story or the other to tell about international arbitration. Nigeria had one not long ago, which was really very a difficult one to explain for a reason, the kind of award that was given against Nigeria. And so there are concerns in developing countries that if they have to submit their revenue to such a process, there are no assurance of fairness in the awards that will be coming from this process. And then the third issue for developing countries are the issue of manpower and resources that are well experienced in arbitral processes, particularly when such arbitral processes are not based on the domestic legislations of those countries. And so this is one of the major concerns of developing countries. And finally, having to run in arbitration in international setting costs a lot of money. If someone has to travel from Abuja or Lagos to London or to Washington to attend arbitration sittings, that costs a lot of money. And so where the tax revenue is not big enough to warrant such a cost, the option usually that will be opened is to forgo the tax instead of following the principle that should determine the tax. These are the major concerns that developing countries have with the proposals as to the tax certainty being proposed with respect to Pillar 1, and particularly issues that have to do beyond Amount A, and then the idea of the mandatory binding dispute resolution. I think I will stop here, Abdul. Thank you very much for listening.
Thank you very much, sir, for your clear presentation, which has brought out these important issues of interest for developing countries. Arbitration, even in the investment world, has been a long specter which has been dangling over developing countries. So thank you for raising these issues, which can seriously bind the policy choices of developing countries going forward in Amount A and Pillar 1 specifically. We now go beyond that and see what are the options for developing countries outside of the two-pillar approach. What can developing countries do to tax the digitalized economy and income from digital services? And in this regard, it is now my genuine pleasure to introduce to you a true champion of developing countries. He's a member of the UN Tax Committee. He has been involved in norm changes from a series of issues. He was the co-coordinator of the drafting group, which has prepared Article 12B, a recent update to the UN Model Tax Convention, which provides a way to tax automated digital services. But apart from that, he has been involved in a whole series of other issues: capital gains, collective investments, royalties, really technical issues, but which really bring a lot of money to developing countries. Ladies and gentlemen, it is my pleasure to introduce to you Mr. Rajat Bansal, member of the UN Tax Committee, who will share with us about Article 12B and an alternative option for developing countries on taxing the digitalized economy. Mr. Bansal, the floor is yours.
Thank you very much, Abdul. And thank you, South Center and Global Alliance for Tax Justice, for inviting me to this forum, a very important forum at this juncture when things are really getting, things are getting hot, should I say. And so it's the time to discuss and decide what view should the world take when everything is almost unfolded and everyone knows what's there on the table. So I'll be discussing the alternate approach developed by the United Nations Tax Committee, of which I'm a member. I'm a member there in my personal capacity. So I'm speaking in my personal capacity as a UN Tax Committee member and not on behalf of the government government of India, for which I work as a government officer. So I'll share my screen. I'm finding it a little difficult to share my screen, Abdul. How do I do that?
Sir, I could share your screen on your behalf if that's okay.
Yeah, it's here probably. One second. So let me shift to. Yes. Is it visible?
Yes, sir, it's visible.
Okay. Thank you very much. So basically, I'm trying to put before you the reason for the alternate approach developed by the UN Tax Committee in a very simple manner, because there may be people here who may not be very familiar with exactly the tax, how the tax rules work. So there was a problem about taxation of digital economy, as my colleague from the UN Tax Committee, Carlos Proto, in the beginning highlighted. Now, this is going on for some time, I would say at least for 20 years. And there was a challenge to taxation, and there was the issue of contribution to domestic resource mobilization for developing countries due to digital economies, which are not amenable to the current international tax rules of permanent establishment, of a fixed place of business in the market jurisdiction, or an agent's presence. So therefore, the debate started and discussion started. And I have listed here 4 major issues which have been at the center of this debate. So first one is whether to tax. Now, the question is whether to tax. Quite a bit of time has been spent on whether to tax, but I would say that this is one major outcome or achievement so far, that everyone, including the other forums which are working on this, are now in agreement that there should be tax. So this major issue, I would say, has got settled, which was unsettled for very long. Now, next question is what to tax. Whether we should tax services rendered through digital means, internet or other digital networks, or we should tax goods also, or we should tax all of them or some of them. And then there was related issue of ring fencing. So this is what I have put under what to tax. How to tax? Now, this is with reference to the 2 possible approaches which we are looking at this time. One is the centralized approach, where M&E-centric approach, total profits of the M&E group will be pooled together, and then they will be allocated to different countries and with subject to certain rules. And the other is traditional approach, where, like we have been doing for a permanent establishment so far of a multinational in a country, and each country calculates what is its share of profit based on a nexus of permanent establishment. So can we follow that approach for this new challenge or not, is the issue I am trying to refer to when I say how to tax. How much to tax? How much to tax is a very important aspect of this whole exercise, because ultimately the proof of the pudding is in eating. So unless you get something, what is the point in all of this exercise? So there the question is whether to tax only a portion of non-routine profits or something else, then which my friend Carlos Proto described in detail. Now, next issue is measurement, how to measure this. Even if we say we want to tax non-routine profits, how to measure them is an issue. And how to measure them accurately is the issue, more important issue. So as all of you must have understood from the presentation made and from your reading of the various proposals, it's not possible to measure this accurately in any manner when there are no accounts in the market jurisdiction specific to that jurisdiction, and there has to be an approximation. So both the other approach as well as the UN approach goes by an approximation. So one cannot say one is superior or other is superior in the process of measurement. It would ultimately be the ease of measurement that would matter here, and that one should keep in mind. Moving on, now why an alternate approach was needed? We already had intensive discussions going on elsewhere, and the UN Tax Committee, why it should look at an alternate approach. So the primary reasons for this are two. First is complexity of the proposals that were under discussion, and the members in the UN Tax Committee felt that there was a need for an alternative approach. At least some of them, and quite a large number of them, felt that there is a need to have a different approach, an alternative approach. Second was the most important aspect as to what we are going to get out of this. Ultimately, any solution that is agreed to has a long shelf life. We all know that tax treaties take years to get changed. Any international solution will be there for some time, a time horizon of 20 to 30 years. So one should be very careful in what we are going to get out of that. Otherwise, this is going to be fixed, and it will leave one fixed with that, which cannot be changed. Next point is, now I would turn to Article 12B, which all of us know about, but not so much perhaps. So first, I will just briefly mention about the United Nations Tax Committee. What does it do? The United Nations Tax Committee is a committee of experts in their personal capacity taken from 25 countries, and both developed and developing countries. Its mandate is to work in interest of developing countries specifically. Tax challenges of digitalized economies was taken up as a work stream for the present committee when the present membership was constituted in the year 2017. Now, the issue there was whether to just observe what others are doing or should we do something more. We consumed quite a bit of time on that. There was a long discussion whether we should only look at what others are doing. After that, due to persistent push by some of us, in the 18th session, we took a decision that we will work independently and will not be mere observers. And we will take into account the work done in other forums. And then the question was, how would we work independently? It was because, it's a 25-member committee. Each one has a different view. So there would never be a consensus. Consensus is a difficult thing. 25 members will never agree to one thing. So how would it progress? Then a proposal was made that we should have proposals from various members invited or a group of members, and then see whether those can be adopted by the committee or taken forward. In 20th session in June 2020, we had a paper, conference room paper number 25, in which I had submitted a proposal. Prior to that, my colleague, Mr. Jose Troya from Ecuador, had also submitted a proposal, and those proposals were discussed. And it was decided due to the interventions by the developing country members, including myself, Carlos Proto, Jose Troya, and several others, that there is enough merit and enough reason for looking into the proposal submitted, and a drafting group was formed to work and draft an article for insertion in the UN Model Tax Convention. Then in the 21st session, we put forward the drafting group, of which myself and Carlos Proto were the co-coordinators. We put forward a draft of the article and commentary. It was discussed extensively amongst the members, and it was continuously refined. And in 21st session, by vote, it was voted for in principle approval for inclusion in the UN Model Tax Convention. That was in October 2020. Thereafter, the refinement of the text and the commentary continued, and finally, in 22nd session in April 2021, it has been finally approved for insertion in the UN Tax Convention. Now, let me briefly talk about why this is also a part of the alternate approach that is being talked about. Why modify tax treaties? The UN solution is an article in the UN Model Tax Convention. purely, and it is going to be there in the Model Tax Convention. The reason is that taxing rights flow through the domestic law, and then treaties are there, bilateral tax treaties which override the domestic law. Treaties do not permit taxation if there is no permanent establishment, as we discussed. Therefore, there is a need for treaty modification. And the gain in that process is elimination of double taxation, because through a treaty, if it is in accordance with treaty, the taxation in the market jurisdiction, the other country will also give credit for taxes paid in the market jurisdiction. Now, what is the role of UN Model Tax Convention? What did we achieve by putting it in the UN Model Tax Convention? Now, the treaties are negotiated all over the world based on two conventions, the United Nations Model Tax Convention and the OECD Model Tax Convention. So these have persuasive value on various countries across the world for negotiating their bilateral tax treaties. Therefore, if an article of this kind gets inserted into the United Nations Model Tax Convention, which is followed by developing and developed countries, then it has a persuasive value, great deal of persuasive value, and countries can probably adopt that into their treaties tomorrow. So that was the objective for putting it in the United Nations Model Tax Convention. Now, what are the features of Article 12B? Briefly, I have put them here. I'm not calling them pillars, but these look like pillars to me. And the first one is, what is the scope? So the scope is automated digital services, which covers a whole lot of services which have been talked about since beginning for taxation under this area. Whenever there was a talk, it was referring to these services which we have tried to cover here. Now, the taxation is under the article is on two, can be in two ways. The first is a gross basis withholding tax at a rate of 3 to 4% recommended in the commentary, and which is a very reasonable rate. And second is a net basis option. Why there is a net basis option? Because there could be MNEs or enterprises which may not have profits, which may have losses. So they should have an option to declare their income on the basis of their actual profits. Actual profits are not measurable, I said that. But the way they have been computed, they take into account the overall global profitability of the MNE group enterprise. And the profits are 30% of a sum, which is calculated by applying the local revenue to the global profitability of the MNE group. Payment basis, instead of a user basis, we have chosen payment basis. There are several reasons for that. In this short seminar, I'll not go into that, but I wanted to list that as one of the major features of Article 12B. Interaction with other articles. The article, obviously, here we are talking about one kind of income taxation, and as is the case with other articles in a tax treaty, there could be an overlap with other articles, for example, with business income article, with royalties article, with fees for technical services article. So those are taken care of, and by clearly specifying which will prevail in case of an overlap. So that is also done. So I would say that Article 12B is a code in itself, self-contained code, which provides a solution to this vexed issue of taxing the digital economies. At this stage, someone may say why we did confine ourselves to automated digital services. The reason is very simple. There may be a ring fencing question there somewhere, but at the same time, what we are not saying that we are not going to provide, we exclude providing solution to other issues. We have at this stage provided a solution to one major segment of which was of concern to the world. Coming to the conclusion, and these are some aspects which I would definitely like to tell you. First is that there is no suggestion to tax digital businesses, which is a matter of domestic law exclusively. What I'm saying is that Article 12B will come into play for a country which has chosen to tax digital businesses, as has been the case for taxation so long in respect of any kind of incomes. And if you look at that, it has been like that. Second is no interlinking with other issues. This is a standalone basis solution. It would be clear that we are not mixing up other problems with this one. We are only confining to a principled solution to a problem which was actually there. And I can see only this as the problem which started the whole discussion and debate. So this is what we are trying to provide solution to. Traditional approach for M&E taxation in a decentralized manner, a very important point, because our Article 12B is similar to Article 5 read with Article 7, to which the countries are used to, especially the developing countries. So what they are not to make any major deviation from what they have been doing so far. And they can simply take one more step ahead and get into the Article 12B mode and start doing it. Implementation, bilateral negotiations, and multilateral instrument. This is basically how to insert Article 12B in the treaties. And therefore, there was in my paper, which I submitted in June 2020 meeting, I had suggested then also that there can be a speedy insertion of Article 12B, swift manner, in all the tax treaties if there is an instrument of like MLI, and countries can sign it, and then it can get inserted in their bilateral tax treaties. Possible end to unilateral measures, equalization levies, and DST is a very important point, and my own thought about this. I think that if you look at the DSTs all over the world, the equalization levies about which so much talk is there and so much of concern is there, because they are kind of circumventing the tax treaties, and for them the tax credit is not available. Those are the concerns. Now, why was that done, even though on recommendation of BEPS Action 1? Because otherwise it was not possible to tax them. Now, I think if Article 12B is inserted in the treaties and these taxes are slightly remodeled and they are made covered taxes under the bilateral tax treaty, which has an Article 12B, then this automatically will take care of the equalization levies and DSTs of the world. And at the moment, I see those are the taxes which developed as well as developing countries have imposed. So this is another feature of Article 12B, which I find to be a plus. So with that, I come to the end of my presentation. I hope I have not exceeded my time, Abdul. Thank you very much.
Thank you very much, sir, for providing that illuminating journey of Article 12B, its key features, how it is such a practical solution for developing countries. Just yesterday, the South Center had published a paper on Article 12B, which I'm going to share in the chat with everyone, by Mr. Kuldeep Sharma, who I think is here in the meeting with us. And this shows how Article 12B protects tax sovereignty of developing countries. And we will soon also be coming out with another paper on the multilateral instrument, which Mr. Bansal had spoken about by Mr. Radhakishan Raval, who is also in this meeting, which will provide more details on the mechanics of how such a multilateral instrument could function and how developing countries can take advantage of it to begin taxing automated digital services. With this, we now move to the topic of rulemaking more generally. Mr. Bansal had provided the story of how Article 12B came about, and our next speaker will speak about the importance of transparency and institutional legitimacy in rulemaking and norm setting, and how these can lead to the creation of rules which are genuinely in the interest of a wide set of participants and not just a select few. So the speaker, excellencies, ladies and gentlemen, Ms. Pooja Rangaprasad. She presently is the Director of Policy and Advocacy at the Society for International Development. She looks after advocacy efforts of the Civil Society Financing for Development group towards UN member states, with special reference to the UN General Assembly, ECOSOC, and regional commissions. Prior to that, she was with the Financial Transparency Coalition and with the Center for Budget and Governance Accountability, where she took forward their work on illicit financial flows. Excellencies, ladies and gentlemen, it's my pleasure to introduce Ms. Pooja Rangaprasad. Pooja, the floor is yours.
Thank you, Abdul and Dereje, for the invitation. It's a pleasure to be here. I don't have a PPT, so hopefully I'm able to hold your attention without it. It's been a great discussion so far, so I plan to build on some of those elements. As Abdul mentioned, as SID, we coordinate the Civil Society Financing for Development group, which is essentially an open civil society engagement mechanism of hundreds of organizations and networks that are interested and engaged in the UN's financing for development process. And of course, FFD is where the G77, which is a grouping of over 130 developing countries, have picked the fight on establishing an intergovernmental negotiation process on tax at the UN for almost 2 decades now. And the history of the FFD process is really about G77 trying to push this issue of democratization of global economic governance. The first FFT conference in 2002 was against the backdrop of the Asian financial crisis of the late 90s. And it was really an attempt by developing countries to recover UN's role on issues of global finance and the economy, and moving away decision-making on these critical issues from undemocratic forums and bodies such as World Bank, IMF, OECD, Financial Stability Board, Bank of International Settlements, and so on. So really the entire architecture of decision-making on issues of global finance and the economy is fundamentally undemocratic. And that's what the FFT process, which was pushed by G77, aims to do. So really, I mean, it's not enough basically to engage with these issues as merely technical issues. I mean, of course, as we've seen, these are very technical issues, but we are not going to get very far unless we also start engaging with the political economy dimensions of these issues. For instance, on international tax, I mean, developing countries have been extremely consistent over the decades on what the core challenge is, and that's the issue of allocation of taxing rights. I mean, this current international tax system was really built on top of the tax practices within colonial trading blocs of the 1920s. And really, the then League of Nations had recognized the need to address allocation of taxing rights between developed and developing countries. Those intergovernmental negotiations then continued in the United Nations. Nothing controversial, that's precisely what the UN was built to do. But of course, once the OECD was established, they unfortunately blocked that critical negotiation process at the UN and have instead upheld a system that is biased in favor of OECD countries and denying developing countries their fair share of revenue over decades now. So essentially, it's a system that has enabled wealth transfers from the South to the North. And I know sometimes as we go down this rabbit hole of OECD negotiations, I think we forget the kind of broader systemic understanding of really what we're trying to address. And essentially, it's about wealth transfers from the South to the North. And of course, developing countries continue to complain for a long time, but was never addressed. It was only when OECD countries themselves were affected by their own inadequate system that we got this BEPS process. It had nothing to do with developing countries. And so here we are at, towards the end of the BEPS 2.0 in the midst of the crisis of the century, and it is still not about developing countries. We're staring at a pillar one that will retain this broken system from the 1920s largely, add another layer of complexity on top of an already complex system, and a pillar two that will be about more revenue for OECD countries. So really, and in the meantime, in this crisis, we actually have several developing countries who are staring at a sovereign debt crisis, because on the one hand, they've been denied their fair share of revenue over decades, and on the other hand, have been encouraged to borrow to meet their development challenges. And so it's really against this context that for me, I've been extremely concerned about all of this discussion and focus on global minimum tax in Pillar 2. It's been concerning because one, it's been a complete distraction from this issue of allocation of taxing rights that remains unresolved. The G24 proposal, the original G24 proposal has already been sidelined in these negotiations. And the other concern for me is that global minimum tax is also normalizing discussions of extremely low corporate tax rates. Of course, I mean, developing countries, several of them have much higher statutory corporate tax rates of 30% and over. The challenge, of course, are the effective tax rates are much lower because of incentives. And this is where you have, a lot of civil society campaigns in the global South that's about addressing those incentives, working with parliaments and so on. But the worry now for me is that we're going to start seeing a race to the minimum, which will be particularly devastating for developing countries, because what the global minimum tax that I worry will do will give legitimacy to investors to simply argue, we don't need incentives, just slash your corporate tax rates to 15%, 21%, and you will, and this is how you will attract investment, the age-old argument. It's also the normative value of global minimum tax is also unclear to me. I mean, if we really go back to addressing this issue of allocation of taxing rights, and if we had an alternative that was really a fair system of allocation of taxing rights, the question for me is, do we still need a global minimum tax? What are the distortions that would still remain if we had a fair system of allocation of taxing rights? And for me, it's really something where we need to see the data and evidence on what those distortions are and what the policy choices that need to be made. And I'm really unconvinced at this stage, and I'm happy to be told otherwise, of what the trade-offs are that would be in developing country interests with the global minimum tax. I mean, the Pillar 2 proposal always came from the North in their interests, and that's where we're going to land with Pillar 2. And I have no doubt that whatever the final package with BEPS 2.0 will be, it will be sold to developing countries as, right now you have 5 peanuts, you will get 10 peanuts instead. As long as we're in this process counting peanuts and we don't focus on how much more revenue has been lost over the decades and how much more we continue to lose in the global South with this unfair system of allocation of taxing rights, we can sit another 50 years in OECD negotiations and continue to tinker at the margins. But really the core issue of allocation of taxing rights will not be won. This battle will not be won behind closed doors in an undemocratic process within the OECD. And we've already seen so far when G24 attempted to address that at a more fundamental level. And this is where, we need to go back to what has been unfinished business in the UN. To the credit of G77 in the UN, they've kept this issue alive. And the reason you're able to keep this issue alive as the South is because you have the political structures to really coordinate your positions on these issues, whether it's within G77 or several subgroupings within that. So you really ensure that all developing countries have a seat at the table. You're not invited to anything. You already have the right to be there and suggest and help design the agenda that is in your interest. Transparency in negotiations is absolutely critical to hold governments accountable. This is about public revenue. And the importance of a neutral secretariat. It's just unacceptable that we have OECD secretariat holding the pen, deciding G24 proposal, is not going to be part of this, and instead come up with a much more complicated proposal. So in negotiations, principles matter, and we've still not seen a principled negotiation process. Even now in inclusive framework, a third of the developing countries are not at the table. Over 100 developing countries were excluded from BEPS 1.0 and only invited to implement things that they were never part of negotiating. And several developing countries were forced to join inclusive framework because of a European Union blacklisting exercise. This is really not the sort of process where we should be discussing these kinds of issues. For me, the UN is also important because we need to start connecting these issues with other economic issues. I already mentioned the issue of sovereign debt crisis. I really don't understand how we're going to comprehensively address that without also prioritizing the resources that are being lost with this international tax system. And we need to start making those connections. The other issue, and I think Abdul briefly mentioned that, is to do with tax arbitration in the investment arena, which has been a big concern. I'm based in India, so I have been very concerned with the recent news that India has lost 2 cases with Kane and Vodafone. For those who may not be familiar, it's essentially about how companies avoid capital gains tax through offshore indirect transfers. Vodafone lost the case in the Supreme Court. Our parliament clarified that was never the intent of the law, to enable the avoidance of capital gains tax. And of course, whether you agree with the retrospective amendments or not, the right of the parliament to introduce those amendments was never in question. We've done this several times in the past. Our Supreme Court has upheld the right of the parliament to do this in the past. But now what you have is a private arbitration process with 4 or 5 private arbitrators from Switzerland, Netherlands, wherever. I have no idea how this process even works because it's all behind closed doors. And they have now ruled that the government of India should forego tax revenue worth almost $4 billion in the midst of the pandemic and have no accountability for, towards 1 billion Indians on that decision. So, if this is how decisions on tax revenue get made, where we can overturn parliaments and the legislation, it's really worrisome. But of course, this is again part of a much bigger issue that developing countries have long been calling for reforms around, which is around investment agreements, investor-state dispute settlement system. And one of the recommendations we've been putting forward in the context of the pandemic is for G77 to introduce a UNGA resolution calling for a moratorium on ISDS cases and the payments. Because really, what are investors going to do? Threaten to stop investing in over 130 developing countries? We need to start seeing the value in really picking these battles much more as G77 and much more collectively, politically. It's simply not enough to see these as technical issues. And this is where I think finance ministries need to work much more closely with foreign ministries to address this in the one space where they are in a majority. So in closing, I just want to say, I mean, we need to stop seeing on international tax, OECD as being the end of the road, the only space where we can make progress on these issues. We really should not be diluting our ambition. The original G24 proposal that has been ignored, you can take that to the UN General Assembly, introduce a resolution establishing an open-ended intergovernmental working group to address this long pending issue that was really started by the League of Nations. And so for me, if like this crisis of the century is not a good time to talk about how we address this colonial tax system, I really have no idea what more needs to happen. But the direction of reforms in OECD is completely unacceptable, and we need to pick this fight in the UN. Thank you.
Thank you, Pooja, for raising those important points of great importance for developing countries, the need to look at these issues politically, the political aspect, looking at them as a whole. So we now would like to open for questions, comments, both are welcome. Please also turn on your cameras. It would add to the collegiality, which is why we chose a meeting format as opposed to a webinar, so we can all interact with each other more. So while please raise your hand if you have any questions. Till then, I can see that there have been a lot of questions in the chat. So I'm going to bunch some of these questions together and pose them to individual panelists, and unless they had indicated the panelists specifically. So my first question would go to Mr. Matthew. So there was one question from Marcos Valadao, who also I think has been associated with the UN Tax Committee, about why are there more developed countries than developing countries in the panels, even though in reality there are more developing countries. So that was one question. And I would add to that another question by Howie Mann, which is that, is there a tax certainty proposal since the Pillar 1 blueprint was released that updates what is in the blueprint? And another question by Lori Johnson or Yori Johnson on Johnston, on how would adherence to international or regional human rights be helpful in dispute resolution mechanisms? So, Mr. Matthew, the floor is yours.
Thanks very much, Abdul, and thanks, colleagues, for the questions. Why do we have more developed economies than developing economies in the panels? I'm not able to answer that question, but that is the proposal that we have that is being negotiated. That has not been agreed, and hopefully we'll be able to achieve a balance when we eventually agree on the composition of the panels. Tax certainty proposals in the blueprint. The blueprint was a political statement as to progress of work as at the time it was issued. And as at now, the blueprint has been overtaken by events, the proposal from the US, which has formed the center of the discussions going forward. Howbeit, the issue of tax certainty had been from the beginning of the process, only that the details were being worked on now. As to adherence to international or regional human rights mechanism, its usefulness to dispute resolution, I believe that anywhere in the world, human rights symbolizes fairness, it symbolizes rule of law, it symbolizes transparency and respect for humanity. This is my understanding of what human rights stand for. And therefore, any arbitral process, which may even include our domestic law court processes, must uphold all of these very laudable tenets. And if they don't, then in my view, such a system will be repugnant to natural justice. And so, in direct answering the question, I would say, yes, any good dispute resolution mechanism must respect all of these virtues, which human rights stand for. Thank you, Abdul.
Thank you, sir. The next question is to Mr. Rajat Bansal. So one was posed by Professor Picciotto about Article 12A and his suggestion that a multilateral instrument, as recommended by Mr. Bansal, could use the alternative version of Article 12A, which covers all services. So your comments on that, Mr. Bansal. And another one by Lakshmi Narayanan on the divided opinion on Article 12A. So he said that Article 12A, the commentary records that there is still elusive consensus on fees for technical services. Under these circumstances, can the UN force adoption of either Article A or 12A or 12B as part of an MLI as another option? And to add to that, Mr. Tony Salvador has made a point about if, in addition to the discussion on Pillar 1, can it be possible to recognize each country's right to tax digital companies without a permanent establishment by imposing customs duties on digital electronic transmissions? And to make this happen, would it be possible to propose that the discussion on these duties be removed from the WTO and transferred to the UN and included in an overall discussion on taxation?
Okay, thanks, Abdul. So thanks to the querists who have raised these questions. Now, on the first question by Saul on having the including the alternative in Article 12A covering all the services, I'm not able to recall that exactly what that alternative is. But as far as I remember, there is a issue of probably physical presence in the state where those services are rendered from. So I would not see Article 12B as a subset of that article. As far as I can recall, I'm not able to recall that exactly. So in fact, I'll not like to comment in detail on that proposal. And for me, if an MLI is designed, then inclusion of Article 12B in that is what I am recommending. Now, Mr. Lakshmi Narayanan's point that there has been an issue in adoption of Article 12A, and why should there be an Article 12B in addition to that, if that is what I have understood as his point. Now, under these circumstances, can UN force adoption of Article 12A, 12B as part of MLI as yet another option? No, as far as everyone knows, that all the bilateral tax treaties of India had Article 12A kind of a provision already. So it's not, Article 12A was not new when it was introduced in the 2017 update of the UN model. And it also was present in so many other tax treaties around the world. So I do not see a situation of Article 12A being imposed on anyone. It was already there and had wide acceptance in treaties between developing and developed countries. And so I have given reasons for Article 12B. There is a problem which needs a solution, and I have given the reasons for the particular solution UN Tax Committee has offered. So I would not look at it as something being forced on anyone. In any case, it's a modification of the tax treaties. So that would be my response to Mr. Lakshmi Narayanan's point. And third one was about customs, probably having customs duties or indirect taxes as an alternative instead of direct taxes, if I have understood that question. Then there are reasons for preferring direct taxes as against indirect taxes, well-known reasons. That is why it is being pursued not only here in UN Tax Committee, but also in the other forum. So to that, my short response will be this much only.
Thank you, sir. We have Stephanie Johnston from Tax Notes. Hello, Stephanie. Nice to meet you. I saw you put your question in the chat, but you're more than welcome to pose it directly if you wish. And if you could indicate the panelist as well.
Sure. Hi, how are you? Thanks so much for this great event. I'm actually very much interested in this because I'm thinking about an inclusive framework and for another story about how it's developed in the past 5 years. I guess my first question is, I guess we have 2 weeks now until some kind of agreement has to be reached at the next inclusive framework meeting. So how much change is realistically expected to happen? I mean, there are so many issues that still remain to be addressed, and to say nothing of what developing countries are concerned about. So how much change can we be expecting the next 2 weeks? This is more for Carlos and for Matthew, I guess, and Rajatu, I guess. Anybody who has any thoughts on the status of these talks here. And I guess the second one is, I'm just curious about whether you've seen this op-ed in the Washington Post about, 5 G20 members, including South Africa, Mexico, and Indonesia. I mean, they've also expressed support for the 2 pillars. I'm just curious about what you all think about this. Thank you.
Thank you, Stephanie. Mr. Proto, would you like to go first?
Yes, thank you, Abdul, and thank you, Stephanie, for raising these 2 interesting questions. Regarding what will happen in 2 weeks' time, good to know, but I have the impression that there will be a political signal saying that there is a need for an agreement. And if an agreement is achieved among 139 members, then the movie starts. So all those jurisdictions, if they continue to be interested, will develop a multilateral instrument according to which obligations and rights will be established. Then that instrument has to be signed by those interested jurisdictions. Whether Pillar 1 or 2 will be together or independent, I don't know. I assume that will be more open for jurisdictions to decide, and probably there is no need to adhere to both pillars in the same instrument. So there will be interested jurisdictions signing for Pillar 1, others for Pillar 2, others for both of them. But then that instrument has to be ratified and it has to enter into force in 2, 3, 4 years' time. That's my impression. So to me, what will happen in 2 weeks' time is, if there is an agreement, that's the condition, there will be a kind of picture among inclusive framework delegates. Then 1 week later, there will be the G20 Minister of Finance meeting. For the G20, they will have another picture. There will be a communique celebrating the global solution, again, if agreed in 2 weeks' time. So nothing changes unless jurisdictions later on sign the multilateral instrument that is going to be developed, and then they ratify it. If there is no agreement, I don't know, probably Article 12b, as described by my friend Rashad, could be an alternative for interested jurisdictions. But we need to be cautious about that, because to have a tax treaty, you need 2 partners, two states. And it is useless that one developing country is interested in Article 12b, while on the other hand, a developed country is not interested. We can develop a multilateral instrument, but it is useless if the main stakeholder does not sign for it. So many MNEs are based in a jurisdiction, and if that jurisdiction is not joining the Article 12b approach, there will be no real impact, even though the multilateral instrument is signed and ratified by the other 200 jurisdictions. That's something to take into account to see how efficient an instrument might be if there is no political commitment. So what we need is a political commitment. It could be under the OECD G20 approach, or it could be under the UN umbrella, but we need a commitment to have everyone seated around the table and desiring to participate in the solution. That's my views. Thank you.
Thank you very much, Mr. Prato. Mr. Gubonjubola, would you like to share your views on Stephanie's question?
I'm sorry, I sort of missed the question. If you can just remind me.
Oh, I just asked, how much change can realistically be expected in the next 2 weeks on these two pillars, given all the concerns that that have been raised during this webcast, and I'm sure behind the scenes as well.
All right, thanks very much. I think one thing that is an open secret is that a lot of consultations are happening across the globe with different jurisdictions, with different blocks. There are a lot of meetings. Yesterday, there was the G24 working group meeting. I know that ATAF is meeting this week. So there are quite a lot of meetings happening across the globe, and all of those meetings are sort of to shift alliances and to see what is doable. One thing that is common to everyone, whether developed or developing economy, is that a decision and agreement is desirable so that we will have a very orderly taxation of the digitalized economy. How to achieve that is where we have the differences. And so whether we are going to have big shifts would depend on how countries are willing to compromise, because which is the name of the game. Where countries are willing to compromise, the G20 countries, the G7 countries, the OECD countries, developing countries, the more people are willing to compromise, the more we will see changes. But where there are no compromises, then I am afraid there may be no agreement. Thank you.
Thank you, sir. Mr. Bansal, I mean, you're not directly involved in the inclusive framework negotiations, but if you'd like to share your views.
Thank you, Abdul. And thank you, Stephanie, for that question. And as Abdul says, I'm not involved in the inclusive framework. I'm not the delegate for the inclusive framework negotiations from my country. But your question really was a very valid question as to what changes one would expect in 2 weeks' time when there are many issues which are not yet resolved. So as a layman or as an outsider, that really puzzles me, that if there is going to be an agreement in 2 weeks' time, and the questions which Carlos Proto put in on his slide about the various, I would call them primary issues for any consensus, to me, at least as an outsider, not as a government officer, those appear to be very pertinent. So that is one. Now, next issue was about, I'm following up from Carlos Proto's answer to your questions, that if UN Article 12B, if the other country does not sign it, then what is it loses its significance to a significant extent. But at the same time, this has made me put my question to everyone as to what is the certainty of signing of the agreement consequent to any consensus that is reached. Our experience so far in respect of MLI, the multilateral instrument or convention for tax treaty related changes for BEPS. Let us look at the record of that. How many countries have signed that? Everyone participated, everyone, even I was a member of that ad hoc group where this was drafted. And later when I was also a part of in the implementation process. And when I look at the results, I find that most important countries have chosen just to implement the minimum standards. So is it going to be like that only again? Or is there going to be a guarantee, what Carlos Proto referred to as political commitment? Is there any such commitment to have a political commitment? I do not really know. So if Article 12B is an uncertainty, then I would like to, I'm not sure about the uncertainty related to the other alternative. So to me, in fact, here, if two countries do not sign and two countries sign, it can still work for two of them. But there, if out of 105 do not sign, then I'm not able to calculate amount A. for me, it becomes very difficult. I know there is something, there is some mechanism there, but still to me, it's very puzzling as to how the amount which was to be allocated to 5 jurisdictions who are not going to sign, how is that going to be taken into account? So that is an aspect I do not understand. And one benefit I see out of Article 12B is that if, as I mentioned in my presentation, that unilateral measures it can take care of. So if a country is ready to, 2 countries are ready, willing to sign it, then perhaps one incentive is to take care of the unilateral measures by signing it. So these are the merits I see in Article 12B. So my response to your questions is like this.
Thank you, sir. The next question is for Pooja, which has come from Matty Conan from the Financial Transparency Coalition. What happens if a state loses a tax arbitration case? Can it be compelled to forego tax revenue if it is already collected by order of the Supreme Court and Parliament in India? There's a similar pending case in Nepal concerning NCEL. Can an arbitration court overturn a decision by a sovereign Supreme Court or parliaments?
Well, I mean, actually, in the midst of the devastating second wave in India, the news that I last heard about on this was Kane Energy was moved courts in the United States to actually attach sovereign assets of India. So I think there is precedent to really force governments to comply by attaching sovereign assets of the country. So it's, I mean, from what I've read in the reporting, India does plan to challenge these decisions, but there is some precedent where their hands can be forced, and this is why I come back to really addressing these much more holistically. I mean, there's the case by Nepal, but also not even related to tax. For instance, Pakistan is staring at a $6 billion ISTS case that they've lost. So, I mean, these are massive amounts. And so this is why we're calling for, G77 to work together and introduce a moratorium on all ISTS cases and payments. I mean, this question of like, the kind of bilateral tax treaty and how do we move this to really being multilateral decisions. I mean, one of the things Africa Group in the UN has been calling for is, I mean, of course, to establish the intergovernmental tax body and then to negotiate a multilateral tax convention, not like the OECD MLI, but like other UN conventions. I mean, the OECD MLI is actually one of the most absurd pieces of convention writing that I've seen. It's basically a tax buffet. You can pick and choose the clauses that you like. I don't understand what the point of that is. And so when I hear there's all this technical expertise in the OECD and we can't match that, it's just a lot of the stuff that I read, it doesn't even really make sense. So, I mean, there are actually better examples of what, multilateral conventions can look like. We've seen this on several technical issues, including climate change, where you have annual conference of parties. So these are universal negotiations where you really fight over, so something like an Article 12B and getting it introduced in multilateral UN tax convention. And it's going to be a pretty tough political fight, but you're finally picking the fight, and developed countries are actually in a transparent negotiation where they'll be accountable for that rather than killing all of this ambition behind closed doors. So, so this is something Africa Group is already calling for, and we think that's a good way forward. We need to really say that we need this multilateral tax convention at the UN, and there are lots of different models that we can look at where you have other UN conventions on very technical issues. So I'll stop there. Thanks.
Thank you, Pooja. Professor Picciotto is going to make an intervention about the relationship between Pillar 1 and Pillar 2. After that, I have one question from my side for Mr. Prato, and then we'll go with a closing round of remarks from all the panelists, and then we'll have final remarks from Fernando from the South Center. Professor Picciotto.
Yes, in a sense, to follow up Stephanie's question, I think it's fairly clear that whatever's agreed on Pillar 1 would only be an interim solution, because a really effective solution on allocation of taxing rights, which is what Pillar 1 tries to address, would need a multilateral tax treaty which all states not only sign but ratify, as Carlos said. Now, that's not going to happen anytime soon. So that's, I think, the importance of Pillar 2. And this is partly, I think, a response to Pooja's comments. What's the point of Pillar 2? We must remember Pillar 2's origin is in the US reforms of 2017, which introduced, on the one hand, a so-called territorial system, but on the other hand, very strong, or relatively strong at that time, base protection measures, both the GILTI and the BEAT. Now, the way they were eventually formulated due to business pressures really rather weakened the effect of them, but now it's clear the Biden administration proposes to significantly strengthen them. Now, that is something all countries can do. All countries can defend, and that is the only way really to push other countries towards a comprehensive agreement on allocation of taxing rights. So what Pillar 2 tries to do is to have a coordinated base protection set of proposals. But that, as I've said, could only be done if it has a fair allocation of the rights to tax under tax profits. So I think that element is much more important than the notion of a minimum tax. You need to define a minimum in order to define what are the undertaxed profits. And from my point of view, it should be the average effective tax rates of all countries in the world, which would be like 25%, as the ICRIT has proposed. But the point about Pillar 2 really is its concerted countermeasures. Now, if you can get concerted countermeasures, then that is the way to nudge all the other countries into saying, well, it's in all our interests really to address the primary question of allocation of taxing rights. So the concerted countermeasures is where I think the real action is. And that can be done even on a unilateral basis, as we've already seen with the US. But as I say, preferably it should be done by groups of countries. And if the Pillar 2 proposals don't result in a fair allocation of taxing rights, I see no reason why a group of source countries, which shouldn't only include what we think of as countries of the South, but could include many other lower income countries, even countries, for example, in Eastern Europe that are mainly host countries to multinationals, I think would have a strong reason to join a concerted countermeasure proposal on the lines of Pillar 2, but with a fair allocation of taxing rights.
Thank you, Professor Picciotto. So we'll now move to the closing remarks. I'll begin with Mr. Proto. I'll ask one question which has been on my mind. It was mentioned in the G24 statement, which was released recently, which was about a deemed routine return for a remote nexus. So for marketing and distribution activities, if they're carried remotely, then can there be some sort of a deemed routine return for these? Your thoughts on that aspect?
Thank you, Abdul. Yes, it's been proposed by G24 group of experts to consider that allocation of taxing rights on that deemed routine activities for marketing and distribution activities that are undertaken by the MNE in the market jurisdiction. That has to be in addition to what is amount A, because it is still considering and remunerating activities according to the current standard, which is the allocation of taxing rights depending on functions, risk, and assets. So that's to avoid any uncertainty. We need to distinguish that remuneration for the deemed routine activity, and on top of that, we still have amount A being applicable to the market jurisdiction. That's been proposed by G24, but as many other proposals by G24, ATAF, or any other group, it's been considered, but not deeply analyzed. So I hope it's still under revision, and in 2 weeks' time, we can have an agreement also on that. Thank you.
Thank you, Mr. Proto. We now move to Saul for your closing remarks, if any.
Yes, as I say, my stress would be that this is an important step, maybe, whatever's agreed this year, but should be regarded as really still progress towards a longer term goal, The longer term goal should be to shift the international tax paradigm. I think we've gone a long way away now from the so-called arm's length principle, the unrealistic approach of thinking you can only tax the individual affiliates of a multinational. We have at least got now an understanding you need to tax multinationals on the basis of their worldwide profits because of the benefits they gain from globalization. And that should be by a formulary approach. So far, we haven't gone a very long way towards that, although Pillar 1 concedes that in principle, the amount allocated is small, and it still proposes to retain the so-called arm's length principle for the bulk of allocations. That's clearly not acceptable. So we need to fix our eyes on the longer term horizon, and a lot can be done by countries moving unilaterally, and as I say, if possible in groups of like-minded countries to introduce coordinated measures which would be based on a formulary approach. First of all, to tax under-taxed profits along the lines of Pillar 2, but even, and bear in mind that tax treaties are the main restriction. Countries have tax sovereignty. Developing countries, in a sense, have the advantage they don't have very many tax treaties. They could seek to renegotiate their tax treaties, as Carlos suggests, by including provisions like Article 12B. I think 12A shouldn't be forgotten. So a lot can be done by countries to move towards what should be the objective of taxing multinationals in accordance with the economic reality that they are unitary firms and their profits should be allocated according to their real activities in each country.
Thank you, Professor Picciotto. I now pass the mic to Mr. Matthew Gubanjubola for your closing remarks.
Thank you very much, Abdul. Without doubt, the current allocation of taxing rights is skewed and badly skewed against developing countries. We also know that the current permanent establishment rules that depends on physical presence is also archaic in view of technological development, wherein entities are able to trade in jurisdictions without physical presence. We also recognize the right of countries to establish domestic rules to tackle these problems. However, it will be more efficient if countries are able to come together and have an agreement and then have a common standard for taxing businesses that are operating without physical presence. As it were, it's important that all developing countries be at the table to partake at the discussions and be able to defend their country positions. Like I know I have said somewhere before, if you are not on the table, you're probably on the menu. And then I also think that civil society organizations have a very big role to play to join in the discussions in defending a fair taxing right for all jurisdictions, not just for developing jurisdictions, but for all jurisdictions. This will be my closing comments. Thank you very much.
Thank you, sir. Mr. Bansal, the floor is yours.
My closing remarks are only about Article 12B. I think the UN Tax Committee has under tremendous pressure of time and by taking into account the situation has come up with a solution which according to some of us in the UN Tax Committee provides a fair solution to the problem. And if I would only say that if it is looked at with an open mind and if it can have influence on, a positive influence on the work elsewhere to make changes which are required there, if that turns out to be the ultimate solution, then also we'll be happy that something was done in the UN Tax Committee. So I'll just say this much.
Thank you, sir. Pooja, the floor is yours.
Yeah, I mean, for me, kind of reading the G24 proposal, the excellent work on Article 12B, I mean, really the background documents and how extensive and comprehensive they were. I mean, when I see all of this technical work from the South, and then you see the mainstream conversation on how only capacity building is needed for everyone in the global South, and they don't know anything, it really disproves so much of that. I mean, for me, I think we should take a little bit of inspiration on what developing countries are doing at the WTO right now, picking the battle on the TRIPS waiver and intellectual property rights. I mean, as we've seen, I mean, of course, it's also a very political issue. There's a long road ahead on really winning that battle. But just picking that fight and drawing attention to the issue of inequality between countries has also resulted in so much public support and conversation. And we're really missing that on international tax. I mean, we're now in the context with this crisis where there is a lot of public support to really talk about these issues in a more comprehensive manner. So I go back to my initial point that irrespective of what happens in this OECD, I mean, I don't see why developing countries would accept this agreement. I really don't, but whatever the political compulsions, that's not the end of the road. I mean, in the UN, G77 continues to pick this fight, and we need finance ministries much more invested in that. And we need G20 developing countries to show much more leadership in G77 as well. And there's really no reason that it has to be the end of the road, no matter what the OECD agreement is. You can come back to the UN and really use the UNGA route to raise the ambition and pick this fight. And what that does is really democratize also the conversation much more and mobilize much broader public support, because this is unacceptable that we still have this system from the 1920s, and it's really time to dismantle that. Thank you.
Thank you, Pooja. Dereje, the floor is yours.
Thank you. I started getting worried by the question Stephanie raised and by the op-ed she also said. All these open issues not discussed, not democratically debated, and now we are going to be source of an agreement or base of an agreement. And I think when such agreements are taken in a hurry, it shows that there are agreements to preempt an inclusive and democratic agreement in the future. So that is why, in this sense, for me, as we used to say at the WTO, no deal is better than a bad deal. I'm worried developing countries will be locked into such a deal to preempt a true deal which will be reflecting their interests. So, as I said, let's be sure that the inclusive framework is not a Bermuda Triangle in which positions of the developing countries disappear. Thank you very much for the lively discussion.
Thank you, Dereje. And for final remarks, I would pass the mic to my colleague, Fernando, who is the coordinator of the Sustainable Development and Climate Change Program of the South Center. Fernando, the floor is yours.
Thank you, Abdul. First of all, in behalf of South Center, I would like to express my appreciation to all panelists for their very thoughtful presentations and comments. I think we had an amazing exchange today, and it's not my intention to summarize such a technical and rich discussion. I just would like to highlight at least 3 issues that call my attention. First, the processes at the OECD are usually dominated by developed countries, and the risk there, if developing countries don't fight for their interests, is to perpetuate the status quo that may relegate developing country interests in the international tax framework. The second thing is that developing countries should not lose the political side of this whole process. We understand the technical character of this topic, as Madame Pooja put it, but this is not only a technical issue, and developing countries should include in its analysis the political economy perspective to have a broader and more comprehensive understanding of what is at stake. Finally, one key message for developing countries is the very fact that the OECD solutions are not the only one. Developing countries do not dilute its ambition in the tax system. There are still some other avenues to explore in terms of international tax developments, such as the works conducted by the UN Tax Committee, which has a specific mandate to work in issues of the interest of developing countries, as Mr. Banzal put it. And ultimately, developing countries can resort to their domestic law to build their own tax systems according to their own realities and needs. Once again, on behalf of the South Center and the Global Alliance for International Tax Justice, I would like to thank you all, panelists and attendees, for your participation. I hope that today's exchange was useful for you and look forward to continuing this type of activities. Thank you very much. Over to you, Abdul.
Thank you all. Good afternoon, good morning, good evening, good night. Thank you for your attendance and your participation. We hope to see you soon. Ciao.